await your verdict. Give us the answer.
We have been hearing two words far more frequently than usual this year. President's rule. In Uttarakhand and in Arunachal Pradesh, the central government imposed President's rule, citing the familiar phrase constitutional breakdown, only for it to be removed by the Supreme Court in both cases. Let's take a quick look at what actually happened. In Arunachal Pradesh, trouble had begun to brew for the Congress-led government last year. In November 2015, 21 Congress MLAs who were opposed to the leadership of Chief Minister Nabam Tuki skipped a Congress legislature party meeting stating that any meeting called under his leadership does not carry any substance and holds no water. In December, Governor Jyoti Prasad Rajkhova, without consulting Tuki, advanced the assembly session from January 14, 2016 to December 16, 2015 and directed the House to consider a motion to replace the Speaker Nabam Rabia. 20 dissident Congress MLAs, 11 BJP MLAs and 2 independents impeached Nabam Rabia in the advanced session. The very next day, BJP legislators brought up a no-confidence motion against the state government led by Tuki. The motion was adopted. Kaliko Pul was elected the leader of the legislative party. In Uttarakhand, on March 18, 2016, the appropriation bill introduced by the Congress-led state government under Chief Minister Harish Rawat was declared passed by the Speaker of the State Assembly following a voice vote. However, 35 MLAs including 9 rebel Congress legislators led by Vijay Bahuguna demanded a division of these votes. The Speaker refused and passed the bill. The Governor of Uttarakhand, K.K. Paul, gave Rawat time till March 28, 2016 to prove his majority on the floor of the Assembly. He also sent reports to the centre stating that there is a prevailing crisis in the state. While the centre contemplated imposing President's rule in Uttarakhand, the Speaker, Govind Kunjwal, dismissed the 9 rebel Congress leaders. This was good news for Harish Rawat. With the rebel legislators out of the way, he would stand a much better chance of proving his majority in the Assembly. However, in the ultimate twist in the tale, just 2 days before the proposed floor test, the rebel Congress leaders released a video that they claimed was a result of a sting operation by a TV channel called Samachar Plus. The video showed Harish Rawat offering bribes to the rebel leaders in order to gain their support for the floor test. The centre moved quickly and showed this video to President Pranab Mukherjee and advised him to sign the proclamation under Article 356, which he did. The governors of Arunachal Pradesh and Uttarakhand, as we have seen, played a key role in both cases. Perhaps that is where we should begin, so that we are able to clearly understand what happened in these two states. So let's start with the role of the governor in the Constitution of India.
The Constitution provides that the head of each federal unit, each state, is that of a governor. Now the governor is normally put into office for a period of 5 years, but he actually also holds that office so long as he enjoys the pleasure of the president. That means at any point of time the president can withdraw his pleasure and the governor goes. So effectively the governor is subject to the central government, which has through the president appointed him.
Article 158 clarifies that the governor is not a member of either house of legislature, whereas Article 163 clarifies that the functions of the governor have to be carried out solely in accordance with the aid and advice of the Council of Ministers of that particular state.
By and large, the governor and the central government have to act in tandem. Now, this sometimes causes a problem when the same party is not ruling at the center and the state, because the governor is bound by cabinet advice of the state government.
Clause 2 states that wherever the governor has been given discretion under this constitution, he shall act on the basis of his own discretion and not necessarily go by the aid and advice of the Council of Ministers. It also clarifies that the governor shall have the power to decide whether he is acting in his own discretion or not.
There are some areas of discretion in which presidents and governors exercise, most often it is in the discretion in calling somebody to take oath as the chief minister of the day. They sometimes in the determining who can form a stable government. But other than those few areas of discretion, the rest of the constitutional machinery is a vast no-go.
So the governor should ordinarily act on the aid and advice of the council of ministers of his state. This was made very clear by the Supreme Court in the case of Shamsher Singh,
where Justice Krishna Iyer used a very felicitous imagery, where he said, not the waters of the Potomac, but the waters of the Thames fertilize our constitution. Because unlike the US presidential model, where you have an executive president and executive governors, we have presidents and governors who only reign but do not rule.
So yes, the role of the governor is largely ceremonial. But when it comes to the limited discretion that the governor enjoys, should we really be surprised when it is exercised in the interest of the party ruling the union government?
See, the governor in the Indian constitution is a bit of an anachronism. You know, historically, the governor comes from British rule, and then in the 1935 Government of India Act, you had almost the same kind of objections that you hear today from the Congress ministries that came in after the elections. They always thought that the governor was an agent of a foreign government, and that the governor had too many powers, that the governor constantly could overrule them. Because of course, in 1935 what India got was a kind of limited government. Now, the Indian constitution is again based largely on the 1935 Act. So, the governor was retained. The only difference was that now the governor reported to the centre. The second difference, of course, is that much larger powers came to the elected government of the state.
Now that we have a basic understanding of the governor's role in our constitution, let's turn our attention to the topic of president's rule.
Under Article 356 of the Constitution, the President is empowered to dismiss the state government and directly rule a state in a situation where the governor has sent a report stating that it is not possible for constitutional government to be carried on in that state.
So things are beginning to get clear now. The governor's report to the President of India about the condition of constitutional government in a state has a crucial role in the imposition of President's rule. What did the drafters of our constitution have in mind when they designed this system?
This provision of 356 in the constitution was because India is essentially a quasi-federal form of government. The states are largely free to do a lot of things, but of course there is a measure of central control, and there is also certain subjects over which only the centre has authority.
Okay, that sounds reasonable. But then how did we go from there to the events in Arunachal Pradesh and Uttarakhand?
The first crucial break, however, the use of central rule, came to displace the first democratically elected communist government in the world. EMS Namboodiripal's government was dismissed using 356, and that was quite largely due to American and CIA pressure on Nehru. And it is said that Indira Gandhi, as Congress president, very strongly advised Nehru to somehow intervene and get rid of that government.
Namboodiripal's government in Kerala was dismissed in 1959. How could that possibly have any bearing on the events of 2016?
See, once the use of the governor and of 356 powers to get rid of inconvenient state governments got established in Namboodiripal's case, then it sort of started becoming more and more of a norm.
Governments at the centre, therefore, started using the President's rule provision in the Constitution to replace state governments and consolidate power in the states. That must have led to quite a constitutional mess when regional political parties started emerging in the 60s.
From 1967 onwards, you had very disturbed polity in India with lots of state governments which were formed, which were non-Congress governments, but were very weak coalitions without an ideology. And you had the famous phase of Ayaram Gayaram. So it often became useful to the central government to encourage dissension, bring down governments, and then impose president's rule.
After listening to this history of the abuse of Article 356, it is reasonable to wonder what the judiciary was doing. Weren't we designed to be a federation of states? And isn't the judiciary the guardian of that constitutional design?
And the most dramatic use of it came finally against Mrs. Gandhi. Once Mrs. Gandhi lost in 1977, the Janata government that had come in proceeded to dismiss a large number of state governments where the Congress had lost in the Lok Sabha elections. The argument was that those governments had lost the mandate to govern because they had lost the Lok Sabha elections. Now that was challenged in the Supreme Court in 1978 in the case of state of Rajasthan, and the Supreme Court then refused to interfere. The Supreme Court, after all, the court also does look at the politics of the moment, and it was a huge watershed moment, and it did look like many of these governments had in effect lost a certain kind of legitimacy. The 77 judgment again gave quite an impetus, and so when Mrs. Gandhi came back to power, she did exactly the same thing, and many of the state governments did not even challenge it. That was because the 77 precedent was too raw and standing there staring in the face.
So the Supreme Court chose to look the other way and not enter the so-called political thicket. One of the more curious conventions of our polity dates back to Indira Gandhi's dismissal of a government during this period.
She took on N.T. Rama Rao and dismissed him when a rebel called NBR, Nadenla Bhaskar Rao, he took the help of Governor Ramlal to lead a rebel government. He was sworn in, and NTR started a tradition then which has sort of now continued and persisted to this day. NTR took away all the MLAs who were supporting him on a bus, travelled to neighbouring Karnataka, which was then ruled by Ramakrishna Hegde, and in effect appealed to the people at large, and then also to the president of the day, saying that, look, here it is said that I have lost a majority, but here are the people who support me. So ever since that day, you have had this kind of system of sequestering MLAs.
But a turnaround in the Supreme Court's approach towards the abuse of Article 356 was not far away.
Ramakrishna Hegde, who had supported N.T. Rama Rao, then resigned in 88 or so. His successor, S.R. Bommai, was not particularly adept at keeping his flock together, despite him asking for an opportunity to prove his majority on the floor of the House. That was not given. The government was dismissed. He challenged it. The challenge was lying in the Supreme Court. Around the same time, in 92, the Babri Masjid happened. The destruction of the Babri Masjid resulted in the dismissal of 4 state governments by the Union and government of Narasimha Rao. The governments were Uttar Pradesh, Madhya Pradesh, Rajasthan, and I think Himachal. So they challenged their dismissals as well. All these challenges came together before the Supreme Court in the Bommai judgment. Now the Bommai judgment squarely had the precedent of the state of Rajasthan before it. And from 77, 294, there had been quite a distance travelled. Bommai essentially then made the floor test mandatory.
The principle laid down in Bommai and relates to two different but related points. One is how should a state government be dismissed under Article 356 of the Constitution of India. The procedure required, that is a report by the governor, has to be informed by certain relevant facts. The relevant facts in the context of a chief minister who is alleged to have lost the support of the house has to be established on the floor of the house. That is a so-called floor test. The chief minister has to face a no confidence motion, and if he comes through, the governor has to abide by it, and if he doesn't, the governor can send his report accordingly. What the Supreme Court's judgment in SR Bommai did was to narrow down the scope of the discretion of the governor in sending a report to the president insofar as imposition of president's rule in that state was concerned.
Bommai also laid down a very important doctrine, saying that in an appropriate case, the court could give effective relief and actually restore governments. They curiously, they took that precedent from our neighbors, from the Pakistani Supreme Court, which had restored Nawaz Sharif's government after a wrongful dismissal. So, the Bommai judgment overruled the state of Rajasthan and said that, you see, if there is a dismissal, that dismissal has to be based on material. The material may not be, the court may not look at the material to determine whether it was sufficient material or the quantum of material, but the court could certainly look to check whether there was relevant material. This is what's called the barium chemicals test.
The Bommai judgment thus underlined the federal features of our constitution and limited the scope of the governor's discretion in sending a report to the president under Article 356. The Supreme Court was also able to solve the issue of how to provide effective relief to a set of people who no longer held the reins of power in a state. Now, how did this judgment from 1994 influence the events in Arunachal?
The Supreme Court has set the clock back, so to speak, to December 2015, before the disqualification of the, before the removal of the speaker, before the removal of the chief minister.
What the Supreme Court has effectively done is to restore the status quo ante, that is, from the time that the governor got involved in the matter by advancing the date of the assembly and setting the assembly's agenda, the game was restored back to that point, and thereafter it was to continue.
The Supreme Court has said that the governor did not have any power to independently and contrary to the aid and advice of the Council of Ministers to call for a session of the state legislature in whatever circumstance, nor send a message as to how the state legislature should function or what measure they should vote upon. The Supreme Court has reiterated that the power of the governor has to be exercised almost exclusively on the basis of the aid and advice of the Council of Ministers, and in the limited area where he has been granted discretion under the Constitution, even his own decision as to whether he is acting on his own discretion is subject to judicial review. In this case, they found that the governor did not actually have discretion to act on his own. He should have, if he felt that the government no longer enjoyed a majority, called for a so-called floor test in the House and decided whether the chief minister still enjoyed the support of the House.
The entire matter was being argued at length in the Supreme Court when the events of Uttarakhand happened also. But the Uttarakhand conflict was largely adjudicated by the Uttarakhand High Court.
The Uttarakhand High Court held that since a floor test had been scheduled and the floor test was to be held in accordance with the judgment of the Supreme Court in SR Bommai versus Union of India, the actions of the governor in calling for President's rule were unconstitutional and directed that a floor test be held. This was ultimately upheld by the division bench of the Uttarakhand High Court and also ultimately by the Supreme Court.
The government of the day of Harish Rawat, which was restored by the High Court, continues even today.
So what do these two decisions? one from the Supreme Court of India and the other from the Uttarakhand High Court, mean for the future of Article 356 of the Constitution of India?
So there are two instances where President's rule may therefore be imposed. The first category is where the Chief Minister has lost the majority in the House, and in that situation it has to be established on the floor of the House before President's rule is issued. The second instance is where there is a constitutional breakdown, as a result of which the Governor sends a report to the President asking for the imposition of President's rule. In the latter case, it is still up to the discretion of the Governor, so long as he shows that there was some relevant material for the imposition of President's rule.
A breakdown of constitutional machinery must be distinguished from mere breakdown of law and order. If the Governor errs, or if central rule is imposed without direct material, or if central rule is illegally imposed, then the Supreme Court or any other or the High Courts can step in and give effective relief.
Bommai, it seems, will live on. Thanks to the Supreme Court's decision in 1994 and the judicial review of the proclamations of President's rule, we seem to be living through a period of decline in instances of abuse of Article 356. What does all this mean for the future of Indian federalism and the role of the Governor in the Indian Constitution?
At the end of the day, it must be kept in mind that India is a federal system. The states are not appendages of the centre. They have plenary legislative and executive powers, and they are democratically elected through a separate process of elections from the central government.
The Governor has to go back to his constitutional role of being friend, philosopher and guide to the government of the day.
Thank you for watching. We will be back soon to help you learn more about Indian law and the practice of law in India. Till then, why don't you immerse yourself in one of our many courses that will help you gain an advantage as you study or practice law in India.